in Mr. Detective Van Adder's pocket going to another side of town, and he never pointed out what stains might have been polluted or planted by Detective Van Adder. There's a reason he didn't do that, but that specter, that image is still floating around of Van Adder driving across town rather than taking the short route. There's a reason that he wasn't specific, and that is because all those evidence stains were collected before the reference sample had been obtained from Mr. Simpson. But still, in light of that misleading impression that was created, we want to maintain possession of all three reference samples, and they exist in tubes, they exist in cards, they exist in swatches.
Well, let me ask you this.
Yes, Your
As
Honor.
to those reference samples,
The defense
three
has already gotten samples
splits.
from them. I'm sorry.
all right, okay. Then I won't concern myself with those.
Yeah, they have already, I could pull out the dates, but the defense has already had access to the reference samples, all three of them. So there, in my opinion, there's no continued need to obtain those items.
Are there any items on this list that you're willing to concede that they're entitled to have in their possession for testing and you have no further objection?
Well, how about Dino and Carlito's Way, for starters? We made progress this afternoon. Well, I think it's incumbent on them to specify what it is that they need, and when I finish in a moment, I think you'll see the reason why, Your Honor. Under the authority of Keenan versus Superior Court, which we list in our letter, we have a legal right to observe these tests, not only to observe them, but to maintain the integrity of the evidence. That's at 126 Cal App 3rd, 576. Defendant, there's no surprise that they should rely on Prince versus Superior Court. I think the court needs to look at what our Supreme Court has said, People versus Cooper, 53 Cal 3rd, 771. They simply assert that this kind of monitoring would violate the attorney-client privilege and work product privileges. And remember, a couple months ago, we went through some discussions about attorney-client privilege and work product privilege. People versus Cooper, in my opinion, disposes of that. And if it doesn't, it's incumbent on them to point out by specifying what it is that they want to do and how much that they're going to consume. You know, if we just ship all this stuff off under their theory, it disappears into the black hole of Calcutta, and we never get to see or find out anything that comes out of it. I've just sent a letter to the defense team today. I want to know what's happened to 47, 50, and 78. We're entitled to present and account for the chain of custody. And I wasn't that actively involved at the time they obtained possession of it, but I think we're entitled to know that. What's left? You know, there have been serious allegations about how terrible the cesspool of the LAPD SID is, and we're entitled to clear those up by demonstrating that everything is accounted for. Remember the time or the chart about Mr. Simpson's reference sample? They've made some serious charges about that, and we're entitled, but if we give them stuff and are never able to account for it, I mean, there are two different issues. There's the chain of custody, and then there's the mandate. To me, the precise legal question is, what legal authority do they have to shield those results? That's our evidence. And we're more than happy to let them be as effective as they can be. But the law in this state and in this country doesn't allow them to be any more effective than the physical evidence allows them to be. And there's the bind. They want to take our evidence, they want to do some testing somewhere, and they haven't even told us that's where the testing is going to be. It is my opinion that the lab that we'll be shipping it to is merely a conduit to prevent us from, what good does it do to tape this and film this in one place if it's going to be shipped out all over the country from there? How are we ever going to be able to account for things? You know, juries ask, I'm sure you've seen some strange questions. They want to see things sometimes. And where are we when we say, well, we shipped it all off to them? I'm sure that they'll probably object to any reference to them having had access in the actual trial, too. I'm trying not to predict the future, but you know that's coming, too. That not only, if they prevail on any of these issues, not only do they reserve the right to attack our evidence even if they've gotten the same answers, as they surely will in this case, but then they'll try to prevent any reference to the fact that they got the stuff in the first place, seriously misleading the jury and depriving us of any opportunity to show them that this is merely about criticizing what our evidence shows, but not about showing that the answers are inconsistent. And I just close on a practical matter. You know, the trial's begun. You can imagine what's going to happen when we say, can we have the glove? We're going to need it about 10 o'clock tomorrow, and then they have to track it down. So at this point, Your Honor, I see three categories. I see the socks and the reference samples. I see all the items of biological evidence that we may intend to pursue once we pursue the question on the sock, the question of, is there any EDTA in any of the samples that we've associated with Mr. Simpson? And what's interesting, there aren't that many samples that we've associated with Mr. Simpson except that have a purely sinister implication to them, except for the crime scene drops. There's blood in his Bronco, there's blood at his house, and there's also his blood, which has been identified on those very same socks, too. But Mr. Cochran has raised the specter that Detective Van Adder or some other dark agent of his did something with Mr. Simpson's reference sample and planted it somewhere. And depending on how the first set of EDTA tests are done, and I can't even give you a timetable on that, Your Honor. We've been making many phone calls since Mr. Cochran made that announcement to the world the other day. But we reserve the right to be able to try to detect EDTA or determine that there is no EDTA in many of these other samples, too.
All right. Mr. Blaiser?
Yes, all right. I'm not going to talk about Mr. Shipman or Carlito's Way. This is absolutely ridiculous. We've made allegations that maybe some of this evidence was tampered with, and now they're saying we can't even look at it to try and demonstrate that. Just because of what our defense happens to be doesn't give them legal authority to say we can't look at the evidence at all anymore. The only authority that Mr. Harmon cited is People versus Cooper, and Cooper does not say that we have to tell them what our tests are going to be, that we have to tell them when we're going to do it, that we have to tell them how much we're going to use, and that we have to tell them what the results are. What People versus Cooper says is that where a sample is so small that both sides can't do testing individually, that it has to be done together, that the defense does not have a right to deprive the prosecution of doing testing by doing it themselves and destroying all of the evidence. That's all that Cooper says. Prince came after Cooper and said that that's what Cooper said, but with Prince, where there's additional materials for the defense to do testing, they have a right to do it, and they have a right to do it in private. Mr. Harmon seems to be forgotten that we have a constitution in this country that provides that the defense has certain rights, that we have an obligation, that there's attorney-client privilege, that we're not required to provide information that might incriminate our own client if indeed that is out there, and that we have a right to conduct our investigation in a way that best allows us to prepare our defense. If Mr. Harmon is here to say that the fact that the socks, that there was an announcement to the press that Nicole Simpson's DNA were on those socks while they were still in the crime lab before they'd been sent for testing, if they can't figure out from that we might make some allegation that when the blood later on turns up on the sock that might have been tampered with, then they aren't very good trial lawyers. Certainly they knew that that was a possibility. Now they're trying to tie up that piece of evidence by saying they're going to do other testing which I don't know has passed Kelly Fry. I don't know whether it's admissible or not. They want to tie that up now so that we can't look at that. With respect to the items that they did tell us that they were still doing some testing on, we have no objection to letting them finish that and then have us look at it. The reference samples, we are interested in examining the tubes. If there was tampering with the tubes, we want to look at the tubes and the labels. We're not so concerned about the blood that's on the inside, but on the manner in which it's been preserved in the tubes and in the envelope, and that's what we would like to inspect with those things. Mr. Conklin pointed out in his opening statement that there had been some conventional serology done on those socks. It was the fact that it was announced that there was DNA testing that had been completed when they had never been sent to the lab that we felt was suspicious and is part of our defense and certainly is a legitimate part of our defense. I would just Close by saying that if the only authority Mr. Harmon has is Cooper, it doesn't support what he has told this court that it says. It does not say that we have to tell them what we're going to do, how much we're going to use, where we're going to do it, and how we're going to do it. We apparently offered to have Drs. Wolf, Baden, and Lee assist the prosecution's experts in conducting tests early on. They were not particularly interested in that. And now we have a right to do the testing ourselves so that we can prepare our defense.
Why do we have to do this examination and split in New York? Why can't you have your people come here, do the physical examination, take whatever splits are agreed upon by both sides here, and then transport on your own those splits for testing?
Some of the examinations that we want to do are probably going to be microscopic examinations of items to determine whether we need to do any testing. That is done in our lab by our people with their equipment. We have no objection to them watching that so that they see what's done. But in our view, it's unreasonable to require all of those people to come back here not knowing what equipment they might have available to them, not knowing whether they're going to have access to the equipment, not knowing how much time they're going to have. We think it's far more reasonable that they be allowed to examine it in their own setting, and we do not have any intention of shipping this stuff all over the country. They're going to be there. They're going to see what we do with it. They're going to see us take splits. They're just not going to see what kind of testing we might do with those splits.
Well, here's the problem. I mean, we're here, we're in trial. I'm told that the people's opening regarding the domestic violence issues will probably conclude in a week or so, and then we will go into physical evidence. They're going to start wanting to present some of this physical evidence. How can I justify, you say it's reasonable, how can I reasonably allow you to take all this evidence to New York when we're in trial here and one of the parties wants to present it?
Well, first of all, we have no objection to them specifying which particular items they're actually going to use, and we'll do those first and get them back as quickly as possible. There are pictures of all of these things. Pictures can be used until the items come back, but I think the number of items that they actually intend to introduce physical pieces of evidence, I think, are relatively small. Much of what we've asked for are things that they feel are unimportant. They haven't even done testing on some of this stuff. So we have no objection to examining things in an order in which that we can get them back as quickly as possible so that they can be used for whatever purpose they want to use them.
All right. All right, counsel, I'm going to want from both sides on Monday morning a list of these items as to what it is, where it is, what type of testing the prosecution wants to subject these to and why. Or I can figure out the why. And I'll take the matter under submission till I hear from the prosecution, because just these lists, Mr. Blaiser, just the list of the numbers here, I would have to sit down and correlate with my own notes, and I don't know what all these items are.
Yeah, we can provide that.
All right.
So that's, you just want to know what tests we want to do.
I want to know what the item is, I want to know where it is, what its current status is, what additional testing you want to do. I'm curious about this EDTA testing, as to how you propose to do that.
I know I won't be able to tell you that Monday. I mean, we've only had 4 days for a commitment that this is what the defense would show. And so I can't tell you where the tests will be done because we're still...
No, I'm just curious as to what kind of test we're talking about here.
Oh, I'm sorry.
Because, I mean, I need to know what type of test, so I know logistically, I mean, are we going to have to, is the only place that you can do this somewhere in Virginia, or is it something we can do locally here? Is it something that one of our local universities could do?
Well, you know, we want to try to get away from Los Angeles because of the charges Mr. Cochran's made, for obvious reasons, that not that we believe them, but for obvious reasons, that we'll invite the court to even contribute. If you have some labs you want to suggest, it can be there are a variety of tests that can be done in a number of places. So
No, I'm just curious as to how we test for EDTA.
Sure.
And the samples, what type of test it is, how long does it take?
The phones are probably ringing right now.
Who does it?
Sure.
Just curious.
Okay.
Okay. All right, thank you, counsel. All right, anything else? All right, let's have the jury. All right, on the record in the Simpson matter, Mr. Simpson is again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, people represented by Mr. Darden and Mr. Gordon. Mr. Darden, call your next witness.
Thank you, Your Honor. The people call Denise Brown.
Raise your right hand, please. Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat on the witness stand. State and spell your first and last name for the record.
Denise Brown, Denise Brown.
Thank you.
All right, Ms. Brown, would you pull the microphone over towards you, please?
Okay.
Yeah,
Okay.
great, thank you. Mr. Darden.
Thank you, Your Honor. Good afternoon. Ms. Brown, you are Nicole Brown's oldest sister.
Yes, I am.
Do you have other sisters?
Yes, I do.
How many?
There's Dominique and Tanya. And of course, Nicole.
And you are the oldest of the sisters, is that correct?
Yes, I am.
And what is your father's first name
Louis Brown,
and your mother's name?
Judita Brown.
And where does your family reside?
We're in Dana Point, California.
Now, if you're the oldest of the sisters, who was directly beneath you?
Nicole was.
And who was beneath her?
Dominique.
And who was the youngest?
And then Tanya.
You know the defendant seated here at the end of the council table?
Yes, I do.
Is your former brother-in-law?
Yes, he is.
When did you first meet the defendant?
Back in 1977,
And where was he when you met him?
he was playing football for Buffalo.
Did you meet him in Buffalo?
Yes, I did.
You were invited to Buffalo?
Yes.
Who invited you?
Nicole did.
Was your sister Nicole and the defendant dating back then in 1977?
Yes, they were.
And you went there to Buffalo.
She asked us to come up, Dominique and I.
So your sister Dominique also went to Buffalo?
Yes.
Was the defendant married at that time?
Yes, he was.
And who was he married to, if you know?
A lady by the name of Marguerite Simpson.
And what kinds of things did you do when you visited the defendant for the first time in Buffalo?
We went to a football game.
Did both your sisters also go to the football game?
Yes, we did.
That would be Dominique and Nicole.
And Nicole.
And was it a Buffalo Bills football game?
Yes, it was.
Did the defendant play in that game?
He was on the sideline. I don't know if he actually played. I don't remember.
And
Certainly. With the recorder, please. All right, thank you, counsel. Mr. Darden, you may continue.
thank you, Your Honor. Both you and your two sisters watched the game that day, is that correct?
Yes, we did.
Okay, and after the game, did you go to the defendant's house?
Yes, we did.
All three of you? You and
Yeah.
both your two sisters?
Yes.
Did anything unusual happen at the football game?
Actually, no. A friend of OJ's was there. He came over and said hello to us. And Nicole said hello, kissed him on both cheeks. I said hello, she introduced me to him, and that was it.
What was that person's name?
Michael Militello.
Yeah, may I just, let me ask you to speak to the microphone.
Okay.
Was that the first time you met Michael Militello?
Yes, it is. I don't know.
Millilitello. Okay. Millilitello. Does that sound about right?
Probably.
You returned to the defendant's home after the game, correct?
Yes.
Anything unusual happened then?
Yeah. OJ got real upset, and he started screaming at Nicole.
Let me see counsel at the sideline, please. All right, thank you, counsel. Ladies and gentlemen of the jury, you are to disregard, I am striking from the record the last question and answer. You are to disregard that, treat it as though you had never heard it. Mr. Darden.
Okay, Ms. Brown, we're not going to talk about anything that occurred between 1977 and December 31, 1984. You understand that?
Okay. Sure.
Overruled. Proceed.
Thank you, Your Honor.
Later. Mr. Darden.
Ms. Brown, your sister Nicole married the defendant in February 1985.
Yes, she did.
Okay. Did you attend the wedding?
Yes, I did. I was the maid of honor.
Do you have a half-sister named Wendy?
Yes, I do.
And where was she living in 1987 and 1988?
Wendy?
Yes.
In Arizona.
Was there an occasion during that time period in which she came from Arizona to your family's home in Laguna Beach on vacation?
Yes, she did.
And did she bring someone with her?
A girlfriend of hers who was also living there.
Okay. And what is the girlfriend's name?
Juliana Hendricks.
And did you, your sister Wendy, your sister Nicole, and Juliana Hendricks go out during that vacation period?
Yes, we did.
Was there ever an occasion when the four of you and the defendant went out and went to the Red Onion in Santa Ana?
Yes, we did.
Did anyone else go on that excursion or that trip that night?
There was Dino Bucola and Reggie McKenzie.
And who was Dino Bucola?
He was my boyfriend at the time.
And who was Reggie McKenzie?
A friend of OJ's.
And he is a former...
Football player.
And was there some plan or agreement amongst the group to meet at a certain location and at a certain time?
We were going to go and meet them, meet OJ, and we were running a little late, and we got there, and he got upset, but that blew over, and then we continued on.
Okay.
Went to the club.
So when you arrived late, the defendant got a little upset, you say?
Yeah.
Okay.
He was annoyed with us, yeah, for being late.
Okay, now it was you, Nicole,
Wendy.
and Julianne?
Right.
Okay. And then the group went out, is that correct?
Right.
Did you all go out in one car?
Oh, there were a couple of cars.
Okay. And who owned the two cars that you used to go out in that night?
I think that night it was OJ's car, and I'm not sure who else was driving, or who else's car it was.
Okay. Did you go to the Red Onion?
Yes, we did.
Is there a bar in the Red Onion?
Yes.
Okay. And did you have something to drink?
Yes, I did.
Really? What did you drink?
That we were all, well, actually, we were all doing shots of tequila.
defendant was doing shots of tequila?
Yes,
Was Nicole doing shots of tequila?
yes.
Did Julianne drink tequila?
I think she may have. I'm not sure, but I know that we were.
How about Reggie McKenzie? Did he drink shots of
Yeah.
tequila?
Yeah, he did too.
Now, were there other persons or patrons in the bar?
Oh, it was packed. There was lots of people there.
And did some of those patrons recognize the defendant?
Yeah, he always gets recognized wherever he goes.
And did the people walk up to the defendant and talk to him?
Oh, sure.
Did he sign autographs?
I don't know if he signed autographs that night, but he's friendly to people. He shakes hands.
Did people in the bar buy him anything?
Oh, they could have. I think the bartenders, they had given him shots of tequila and things like that, sure. I mean, that happens when he goes out.
So the drinks were free?
I'm not saying all of them were, I'm not sure, but people do tend to buy him drinks and they were buying us drinks too because we were with them.
And did you see the defendant drink shots of tequila?
Mm-hmm. Yes.
Okay. Did anything unusual happen that night in the Red Onion?
Yes.
What was that?
Well, we were all drinking and goofing around and being loud and dancing and having a great time. And then at one point, OJ grabbed Nicole's crotch and said, "This is where babies come from, and this belongs to me." And Nicole just sort of wrote it off like it was nothing, like she was used to that kind of treatment. And it was like, I thought it was really humiliating, if you ask me.
And when he grabbed your sister's crotch and said, "This is where babies come from," is that what he said?
This is where babies come from, and this belongs to me, and this is mine.
And when he said this, and when he grabbed her in the crotch, were there people around?
Oh yeah, the bar was packed.
Strangers?
Yeah. Yeah. He was talking to the strangers.
Did your sister Nicole react to this at all?
She just kind of wrote it off and just, shrugged her shoulders. Stop it or whatever. I mean, it was, I don't know. She didn't really react. Thanks.
Did the defendant appear mad or angry or upset when he grabbed your sister's crotch and made these statements in front of these strangers?
No. He wasn't angry. It was his. That's the way just the way he acted, the way it was like, this belongs to me, this is mine. He wasn't angry when he said it, he just made it a point. He wanted it to be known, but that was his.
Was she wearing a dress or was she wearing pants, if you recall?
Oh, I don't remember.
And during the time that these strangers were approaching him and shaking hands and things like that, did he appear to shy away from the attention at all?
Oh, no. No, not at all. He loves the attention. He loves it. He's got a big ego. It feeds his ego.
Yes, please. All right, thank you, counsel. Ladies and gentlemen, I'm going to instruct you to disregard the last answer regarding the defendant's ego. That question and answer is not relevant to the issue before the court at this time. And Ms. Brown, if I can ask you, would you please listen carefully to the question that the attorneys asked of you, and if you would answer just the precise question that they asked you, this will go a lot easier.
Okay.
All right, thank you.
Sure.
Mr. Darden.
Thank you, Your Honor. You okay, Ms. Brown?
Yeah.
Let me direct your attention to the La Cantina restaurant. Okay?
Okay.
Are you acquainted with someone by the name of Ed McCabe?
Yes, I was.
This is someone you've known over the last decade or so?
I've known Ed for a while. I used to date him.
And when did you stop dating Ed McCabe?
Oh, I think we may have gone out for a year or two, maybe 2 years.
You still speak to Ed McCabe?
Not too often.
Okay. And in what city and state does he live?
He's in New York.
You recall an occasion when you and Ed McCabe and Nicole and the defendant went out to dinner?
Yes, I do.
Okay. And where did the four of you go after you left the La Cantina restaurant?
We went to OJ's house. OJ and Nicole's house.
On Rockingham?
Yes.
Now, had you had something to drink at the restaurant before?
Yeah, margaritas.
And did the defendant have something to drink?
Yeah, we all did.
All four of you?
Yes.
Okay, and what did you do when you returned to the defendant's home on Rockingham?
We were sitting at the bar talking, having some more drinks, and talking.
Okay, and while you were talking, did you say something to the defendant?
Yes, I did.
What did you say to him?
I told him he took Nicole for granted, and he blew up. He got...
Right. Ms. Brown, if you would, don't volunteer anything beyond the actual question, please.
Okay.
Thank you. Mr. Darden.
You told the defendant that he took Nicole for granted?
Yes,
Why did you tell him that?
because she did everything.
Sustain.
On 352 grounds, Your Honor?
It's irrelevant. Why this witness thinks that Ms. Brown Simpson was taken for granted is not relevant. What's relevant is the fact she made the comment and any reaction to that comment.
What reaction, if any, was there by the defendant when you told him that he took your sister, Nicole, for granted?
He got extremely upset.
And what
He-
happened next?
He started yelling at me. I don't take her for granted. I do everything for her. I give her everything. And he continued. And then a whole fight broke out. And pictures started flying off the walls. Clothes started flying. Ran upstairs, got clothes, started flying down the stairs. And grabbed Nicole, told her to get out of his house, wanted us all out of his house. Picked her up, threw her against a wall. Picked her up, threw her out of the house. She ended up on her... She ended up falling. She ended up on her elbows and on her butt. Then he threw Ed McCabe out. We were all sitting there screaming and crying. And then he grabbed me and threw me out of the house.
Are you okay, Miss Brown?
Yeah, it's just so hard. I'll be fine.
Your Honor, if it pleases the court, can we adjourn and continue this Monday morning? Your Honor, would the court instruct Ms. Bailey to assist Ms. Brown if she needs assistance?
No. All right. Ladies and gentlemen, we're going to take our recess for the afternoon. Ms. Brown, if you just stay there for just a second. We're going to take our recess for the afternoon. Please remember my admonition to you. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to speak to you about the case or speak to anybody else about it. Do not conduct any deliberations till the matter has been submitted to you. I'll see you back here Monday morning, 9 o'clock. Have a nice weekend. Thank you, counsel. Anything else we need to put on the record? All right, we'll stand in recess Monday, 9 a.m.